Hey everybody, John Skiba here from the Consumer Warrior YouTube channel, and it is Thursday night. Hey everybody, welcome back to the channel. Welcome to Thursday night. We're making it. We're almost through the work week. It's Thursday evening. That means it's all downhill from, we just got Friday left and we're good to go. I'm John Skiba. I am the founder of the Consumer Warrior YouTube channel. And the whole purpose behind the channel, I'm an attorney in the state of Arizona. I do bankruptcy. I do defend people who are being sued by their creditors. And the whole reason why I started this channel years and years ago is to provide information and approaches and tactics and strategies on how to deal with aggressive debt collectors and really just to deal with debt problems in general. Even though I am a licensed attorney in the state of Arizona, I'm not licensed anywhere else. I'm just some guy talking away on YouTube. So take that for what it's worth. If you need real legal advice, if you're in the state of Arizona, my number is right here below on the screen. Give us a call. I do a free consultation. If you're not in Arizona, I'd recommend you contact an attorney in your particular state. So the way we do it is if you do have questions, you can, if you're on YouTube, you can go ahead and put it in the chat section. I'll put them up here on the screen. I'll read over them and I'll give you some of my best thoughts on it and some pointers and different directions, maybe to ways to kind of think about things. I was going through the comments on the channel, and I mentioned before, it's awesome. There's a lot of people that are engaging there and providing information, but the comments are such that I can't respond to all of them like I used to. So I try to go through and find a few that might have some kind of universal interest. I had this one. This person said, I filed a bankruptcy, Chapter 7, a few weeks ago. I just went on Credit Karma, and only TransUnion is showing 0 under collection. Equifax is still showing the full amount of my debt, like I never filed. So this is a good question as far as this connection between credit reporting and filing bankruptcy. What your credit report will look like when you go through the bankruptcy process, and how, what it should look like if there's problems. So when you file for bankruptcy, within a few days, the bankruptcy filing itself will show up in the public records section of your credit report. It'll stay there for 10 years and in Chapter 7. So it stays there, it shows up that you filed as a Chapter 7 bankruptcy. However, the individual creditors listed on your credit report will likely not change. I'm actually surprised that within a few weeks that TransUnion was showing 0 on some of the creditors. Usually, the creditors don't update that information until the bankruptcy is discharged, which takes about 4 to 5 months for the whole case to kind of wind its way through the court. And when you get that discharge order, that then means that the debts have been legally eliminated. I usually tell clients to check their credit report 30 to 60 days after the discharge order is entered, because it takes usually a couple reporting cycles for everybody to get notice of the discharge and then to recognize that there's nothing owed. And so they don't delete the line of credit completely. They just zero out the amount owed, and then there's usually a notation there that says discharged in a bankruptcy. Something that's a little bit concerning to a lot of people is that even your secured debts will often show 0. Mortgages, car loans, and that gets kind of complicated. But the reason why they're doing that is because technically the bankruptcy discharges all those debts: credit cards, personal loans, medical bills. It also discharges the liability on a car loan and a mortgage. But before you get too excited, there's no free car, there's no free house in Chapter 7 bankruptcy, because there's 2 parts to those loans. There's the promissory note, which says, okay, here's how much is owed. That's what the bankruptcy is technically discharging. But there's also a security agreement. Like with a mortgage, there's usually like a deed of trust that connects the loan to the home. The car loan has a lien on your title. And so the bankruptcy does not eliminate the liens. And so for the all practical effects, you're still going to have to continue to pay. If you want to keep your car, you got to keep paying the payment. If you want to keep your house, you got to keep making the payment. But the confusing thing is a lot of people will go look at their credit report and it will show 0. It'll show that there's nothing owed on it, and they don't have to report good or bad information once it's over. There's actually some protections built into that. If you were to, if you go through bankruptcy and the car is surrendered, or you've kept the car, but A year after your bankruptcy, you can't afford it anymore. You could surrender it and you wouldn't owe anything on it. So it can get a little complicated, but that's kind of how it plays out. Most people, it does stay on your credit report for 10 years. Most people, recover about 18 to 24 months. Like FHA will do mortgage loans, again, 2 years after a bankruptcy, so will VA. And other lenders are 3. So that's kind of what you're looking at. If you're looking at Chapter 7, we're seeing a lot of bankruptcy filings right now. The economy being what it is, job markets, inflation, everything like that. I feel like it's kind of been pent up because with the inflation and everything, people have gone into a lot more debt than they did before. So that's kind of what you're looking at. So, all right, well, let's jump into if there's any questions over there. Let's see here. Ricky has something kind of interesting here. It says Equifax and Credit Karma showed me as deceased and all accounts closed. I had to call them and they claim it was a glitch in their system. I'm glad it was just a glitch, Ricky. That's a pretty serious problem there. It goes, but your point here actually brings up something to be aware of. When it comes to credit reports, a lot of information can be inaccurate. The statistics are, I think it was like 80% of people's credit reports had inaccuracies on it. And so when you look at your credit report, you can look for things that are inaccurate and you can dispute it through the online dispute systems that each of the big 3 credit reporting agencies have. You got to remember, these are private companies. They're so ingrained in our lives that we almost treat them as kind of like these quasi-governmental entities, and they're not. They actually sell your information to debt collectors and debt buyers. I've talked before, all Experian, TransUnion, Equifax, they sell what are called trigger reports to the junk debt buyers. And what that does is that when something happens on your credit report, certain things, you buy a car, you buy a house, you sell a house, things like that, that's a trigger that they then send a notice to the debt collector. Because sometimes people will come to me and say, gosh, it was such bad timing. We were just getting ready to buy a house, and now all of a sudden they sue us, or they're showing up with this thing, or, the people feel like it kind of piles on. It's not coincidence. It's because the credit reporting agencies, the credit bureaus, are selling your information to creditors so that they can collect against you in a more efficient manner. So that's something to be aware of. But to Ricky's point, the information is often not correct. And that's why back in 2017, like if they get a judgment, like if a junk debt buyer were to sue you and get a judgment against you, in the old days, pre-2017, that would show up in the public records section, that you have a judgment against you. Judgments no longer show up on credit reports. They changed the reporting rules. The reason being because of what Ricky's highlighting here, and that is there's mistakes that are made. There's people who have very similar names, and it was just, there were so many problems with it that they said, look, we're not going to list these judgments anymore because it's too hard to tell who is what. Anytime I think of that, I think of the boxer, George Foreman. He has, I can't remember, it's like 4 or 5 sons, and he named them all George Foreman. And I think, that's cute. But I always think their credit reporting must be nuts because I've seen it, where like you see like a father-son with a senior and a junior, and their credit reports are often, they look one and the same. And if one of them has bad credit, it starts influencing the other one. So just kind of the bankruptcy attorney perspective on naming your kids that keep them somewhat different so that they don't have credit issues. So, all right, let's see here. William said, what are the options if you're behind on your car payment? Can a bankruptcy stop repossession? Yes, 100%. It's one of the main reasons people file for bankruptcy, whether it's Chapter 7 or Chapter 13. The moment that the bankruptcy case is filed, the court puts an order in place called the automatic stay. And it's automatic. It stops all collections. It stops repossessions, foreclosures, phone calls, snotty letters, emails, everything stops. And so the one thing you need to know with bankruptcy, though, if they're out, repossession usually doesn't happen until you're 2 to 3 months behind on your car payment. Chapter 7 does not have any real mechanism to get that brought current. It's going to delay repossession by 4 or 5 months. But if you can't get the car loan caught up in that time, as soon as the Chapter 7 is over, they can then start to look to repossess the car again. And so what you may want to look to at Chapter 13, if you're really behind on the car, It allows you to keep the car, and it gives you up to 60 months to get caught up on those missed payments. So it's a much better option to kind of bring it current. But if it's just a payment or two, I usually still recommend a 7 and then work with the lender to get something squared away there. So yes, that's a big reason that people file bankruptcy. So, all right, let's see here. It says paying my last credit card that was sent off to collections off tomorrow in a settlement. 39% of the total balance. That's not a bad deal. Third card settled. Thanks for all your advice over the last 2 years. Awesome. I'm glad you're the light is at the end of the tunnel here. You're getting that done. All right. Are you still considering a National Collegiate Student Loan course? I'm considering a lot of things, Don. my problem is time that things are very busy. I've got a one-man show here. I mean, I've got staff here at my office, but I have this day job of practicing law that makes a lot of things difficult. But it is a good one. National Collegiate Student Loan Trust is one of the larger junk debt buyers out there. And there's a lot of good defenses against cases like that. So I appreciate the reminder, and I will keep working on that. I'll get that done. So, all right, let's see here. Does a creditor have to send me proof they are owner of the vehicle or they bought the vehicle? If so, what evidence would be satisfactory to the courts or to an attorney? Simply sending a letter. Usually if there's a change in ownership, they've got to provide you ownership, notice of the change in ownership within 30 days. And usually a letter is sufficient. The key with a court is that you've got to have someone who can do what's called authenticate or lay foundation for any document that comes into court. So that can be done with like a motion for summary judgment with like an affidavit. If you're going into court, it's going to have to be done with someone who has understanding and knowledge of how that company keeps and maintains their records. So, all right. ALK says, should I let my auto lender know I'm filing before I do it so I can figure out a way to keep making payments? I've read they normally close online accounts. So if you're thinking, so it sounds like you're looking to file for bankruptcy. I usually don't recommend letting your creditors know, particularly secured creditors know ahead of time if you're going to file for bankruptcy. The reason is, in rare cases, if they're already in the process of trying to repossess the vehicle, they may actually accelerate that and try to get it repossessed before you actually file. And, even after you file, sometimes you can get the car back, but it's just a lot more trouble and hoops to jump through. So I don't think there's really a reason to do it. It is true that they usually cut off online access for making payments while your Chapter 7 bankruptcy is active. I can tell you why they do it. I can tell you why I think they really do it, but I can tell you why they say they do it. That automatic stay that I talked about briefly, when you file the bankruptcy, the automatic stay goes into place. It stops all collections. And not only that, if the creditor tries to collect, the bankruptcy court can sanction them for doing it, assess a fee, a fine against them. And so they will tell you, hey, we don't want to have anybody trying to misinterpret what we're trying to do here. So we're not going to send you monthly statements during the bankruptcy. We're not going to give you online access because we don't want to violate that automatic stay. The courts know, everybody knows that giving you online access to make your payment is not a violation of the stay. I think they do it to be a little bit vindictive, in my opinion, to make your life harder, because during the bankruptcy, you often have to either go pay like your car payment in the branch, or you're going to have to actually mail it into them just during that time. So, all right, Michelle, this is actually a really good question. Will I have to pay taxes on my Chapter 7 discharge debts? So if you were to, outside of bankruptcy, if you were to try to settle your debts, if you go up to your creditor and come up with some deal and they say, okay, like that previous one, you can pay 39% and then we'll forgive the rest. There is a good possibility, and frankly, under the law, you're supposed to get it, but I don't always see the creditors do this. But if you settle an account right now, next January, anything, I think it's over $600 still, that's forgiven, they're going to send you a 1099-C in the mail. And you get it in January because you're supposed to use it with your taxes. And so the 1099-C essentially counts as income. So for example, let's say you have a $10,000 credit card. They agree to settle it for $3,000 and forgive $7,000 of it. They will then issue you a 1099-C for $7,000, the amount that they forgave. And then you have to use that in your taxes, and that's counted as income against you. And so you can see that it could actually, you'd have to end up paying taxes on that $7,000 forgiveness that they gave you. Now, if you expect a lot of 1099-Cs or a big 1099-C, I recommend using a CPA for your taxes that year, because there are ways around it. If you're technically insolvent, if your debts exceed your assets, then you're not going to be liable for any additional 1099-C liability. But to this question that Michelle gives is a good one, because a lot of people are concerned, look, I have a ton of debt. I'm going to file a Chapter 7 bankruptcy. Am I going to get, just wallop to the big tax debt next year? And the answer is no. And the reason why is because the IRS code makes a difference and makes a distinction between debts that are forgiven by a creditor in like debt settlement and debts that are legally discharged under the bankruptcy code. And so if the debt is discharged under the bankruptcy code, it's not forgiven, it's being forced on the creditor, and there's no liability there. So that's a good question. So let's see what else we got here. Don said, I was sued 4 years ago. Day of trial, local attorney showed for National Collegiate Student Loan Trust with no knowledge of case dismissed without prejudice. 4 years go by and getting Transworld letters again, trying not to get sued again. So Transworld Systems Inc., TSI, is the servicing company for National Collegiate Student Loan Trust. You've got to be getting near statute of limitations on that, regardless of which state you're in. And the further it goes out, this gets a little bit complicated, because usually student loan cases are installment loans. And so they have a specific number of payments. It's 20 years with a specific payment each month. The statute of limitations on those runs a little bit differently than like on a revolving account, like a credit card, because each individual monthly payment has its own statute of limitations, unless they've accelerated the note. Let me explain what that is. So acceleration of the note is them saying, okay, this loan is a 20-year loan. It's not supposed, the payments extend out to 20, 25 or whatever like that. We're just going to say, to heck with that. Everything's due right now. We're going to accelerate it. We're going to bring everything due and say, you owe us the whole amount. If they accelerate the loan, then from the date of acceleration, that's when your statute of limitations starts running as to the full balance. But if they haven't accelerated, and I see often with these National Collegiate Student Loan Trust cases, they don't accelerate it, at least not until they file suit. You can look back, and I look back from the date the lawsuit was filed, and I go back whatever the statute of limitations is, like in Arizona, 6 years for written contracts. And any monthly payments that were due before that 6-year date. So date of filing, go back 6 years, and any of the payments due before that are outside the statute of limitations. And so not only can you get those thrown out, I think there's a good argument you could counterclaim them under the Fair Debt Collection Practices Act for suing you for debts that are not legally owed. So I don't know how I got off on that from your question, Don. My point is you have some good, strong defenses. Also, if you were to get sued, go over to the Consumer Financial Protection Bureau and research National Collegiate Student Loan Trust. Look up the consent order that was entered against National Collegiate, as well as Transworld Systems Inc., TSI. It's crazy. TSI was just nailed by the Consumer Financial Protection Bureau for submitting false affidavits, having their witnesses testify about things that aren't they don't know anything about, and doing things like this, having attorneys show up who had no knowledge of the case. So you may want to take a look at that. So, all right, let's see here. See what Pam has to say. I have a hearing on my motion to dismiss and compel arbitration. What should I say so the judge grants your motion? Well, I mean, usually if there's a hearing on it, that means a judge has questions. So sometimes because it's your motion, they'll likely ask you to go first, or the judge may just jump in with any specific questions. I think, really what you're wanting to focus on is saying, look, judge, this is their contract. It's not you making something up. You're just trying to ask for what their contract provides either party. Sometimes a compromise can be, and sometimes judges don't want to dismiss the case to compel arbitration, but what they may do is they may stay the case. And so you could even do a concession right off the bat saying, judge, if there's concerns about dismissal, how about we stay the case for 90 days to allow us to go initiate private arbitration. And that way, if arbitration doesn't get initiated, the case can come back. And that's why I will often recommend, actually, if the judge stays it, If the creditor doesn't want to go initiate arbitration, I'll go do it. Because I think that one, you can deal with it in the arbitration process if they follow you in there. And two, often they don't want to, and it can result in a better resolution of the case altogether. All right, let's see here. Tina says, started filing for a Chapter 7, forgot to add an old job in 2022 to the schedule. Now I may be over income for Chapter 7. Attorney is talking about a Chapter 13 and I refuse. Can I cancel all of this? So a lot of it depends on whether your case was filed. And if you're still listening to this, maybe you can put that in the notes here in the chat section. If the Chapter 7 case was filed already, it's actually filed with the court, you have a case number, and now you've come in with some additional income that puts you over the means test, and you're going to have to convert it to a Chapter 13 because your income is too high, then the answer is likely no, that you can't just cancel all of it. Chapter 7, if you file a Chapter 7, you can't back out voluntarily. You have to get approval from the court. Creditors can object, your trustee can object, and it's very difficult to get out of a Chapter 7 once you file it. Chapter 13, on the other hand, you can voluntarily dismiss. If you're in a Chapter 13, you can dismiss the case and back out of that one. You can cancel it. However, what you can't do, there's a provision in the Bankruptcy Code that says if your case has been converted from a Chapter 7 to a Chapter 13, and then you try to file a motion to dismiss, you don't have the automatic right to do it. You can do it, but then the courts and creditors and people like that can come in and object. So essentially, if it starts as a 7, gets converted to a 13, there's no right to automatically dismiss it. Okay, Tina following up. It's been filed. So yeah, so that's probably what your attorney is telling you is, look, we can convert this to a 13, but you're not going to be able just to back out of a Chapter 7, likely at this point. You can convert it to a 13, see what can be done there. It's possible to file a motion to dismiss, but if there are, it kind of depends on if there's any assets. I mean, maybe talk to your attorney about this. If your Chapter 7 doesn't have any assets that can be liquidated, they may agree to a dismissal, but at the same point, the judge may say, no, you're going to have to go into a 13. You're going to have to account for that additional income, and you're going to have to make some type of payment to your creditors. So sorry, Tina, that's a tough one. And, the bankruptcy process can be, the difficult part is that it requires so much information. The typical bankruptcy filing is about a 100-page document that we file. When I first started filing bankruptcies back around 2004, it was about a 45-page document. So it seems like it just gets bigger and bigger each year. There's more stuff that has to be disclosed, and it can be kind of, what do you call it? It's just, there's a lot of information. So Tina says, I told me I refused to file 13. I have no assets. I was fighting a bank levy. So if it's still an active Chapter 7, it may be difficult to get out of that. You may have to convert to a 13 because if your income is too high, the U.S. trustee will object and they'll push it over into a Chapter 13. So I would talk to your attorney there a little bit more if there's any way to seek a dismissal. I saw you said you're in Indiana. They're going to know local practice with the judges there. I know in Arizona where I practice, that would be kind of difficult. So, all right, that looks like that's it for the questions. Hey, I appreciate everybody checking in tonight. If you're not a member of the Consumer Warrior University, go ahead. It's the top pin there. Go check that out. We have a good group there, a lot of questions, a lot of information and tips and strategies, and you get full access to every one of my online tutorials. And I will have one for the National Collegiate Student Loan Trust. I'm not going to say near future, but one of these days I'll get that done. But I appreciate you checking in tonight, and we'll catch you next week.